This is RN Breakfast. A very good morning to you. The private army of more than 50,000 and a key force in Russia's battle against Ukraine, the Wagner Group, has been accused of human rights abuses and atrocities in Russia's war. And now there are calls from the opposition here in Australia to list them as a terrorist organisation under Australian law, alongside groups like IS and Hezbollah. But what difference would that actually make? Senator James Paterson is the Shadow Minister for Home Affairs and Cyber Security. He joins me now. Welcome back to Breakfast.
Good morning, Hamish.
One of the key reasons to list a group as a terrorist organisation is that they might pose a threat to Australia or Australians. Is the Wagner Group doing that?
There's really two reasons why we list terrorist organisations in Australia, Hamish. The first is the practical reasons. It makes it unlawful to associate with them as an organisation or to raise funds on their behalf or recruit people on their behalf, for example. But there's also a moral component to it. This is an opportunity for Australia to state our values and often to stand in conjunction with our allies and say that we don't tolerate the activities and the conduct of the particular group. So, for example, it's been common in the past for Australia to list a number of terrorist groups around the world that don't present a direct threat to Australia or Australians, but nonetheless we find their activities reprehensible. For example, some of the Islamic State groups that have operated out of Africa, not likely or capable of producing terrorist activity in Australia, but nonetheless we think it's important for us to take that stand. And I think Wagner very comfortably sits in that category as well.
I'm just trying to understand, though, what the connection is with Australia beyond the, clearly the morally abhorrent activities that they're pursuing in different parts of the world. I mean, is there any indication that the Wagner Group might be getting funding from Australia? Is there any indication that they may be trying to recruit from Australia? Is there an actual connection?
It's not necessary to list a terrorist organisation for them to have a direct connection to Australia, and sometimes we list them as a preventative measure because we don't want Australians to think that it might be a good idea to travel overseas and join their cause. We don't want Australians to think it's acceptable to recruit on their behalf or raise funds on their behalf. Certainly there are supporters in Australia of Vladimir Putin's invasion of Ukraine, and this wouldn't criminalise people who have a political view about that, even though we might find their views reprehensible. What it would criminalise is people who are actively involved in supporting those organisations, and I think that's a prudent.
But my question is, are there people in Australia doing that?
Well, I haven't been briefed on that, Hamish, and really only the Department of Home Affairs and its agencies is capable of arriving at a conclusion about that, and that's why I've asked the government to seek advice from the Department of Home Affairs about whether or not Wagner can be listed. And I've also said that if it's necessary to change the law to facilitate that listing, then the opposition would provide the government with bipartisan support to do so. But a number of independent experts, including an academic from the Australian National University, quoted in the Sydney Morning Herald yesterday, said there are no impediments if the government chooses to do so.
If they're a terrorist organisation, what's their ideology?
That's a really good question. Terrorist organisations sometimes have very clearly articulated ideology, which can be political in nature or religious or philosophical in nature. The Wagner Group, I think, is certainly has a political view about the people of Ukraine and the fact that Ukraine is not a state that doesn't have its own sovereignty and right to exist. That's been very clearly articulated by Wagner leaders as well as Putin and his allies.
I just wonder whether designating this group a terrorist organisation somewhat lets the Russian government off the hook, given the proximity of Vladimir Putin and the Russian state to Evgeny Prigozhin, the leader of the Wagner Group.
I'm not sure how in any way, in shape or form, listing a key army or a private army, as you say, of the Russian state is letting them off the hook. In fact, I think it is...
Well, just to call them a terrorist organisation, does it somewhat sort of ill-define them in terms of what they are, which is an arm of the Russian state and of Vladimir Putin, the president?
No, I don't agree, and I don't see that line of argument. I mean, it's been widely reported that the United Kingdom is likely to about to list them as a terrorist organisation. The French Parliament has voted unanimously to refer the matter to the EU for their consideration. The United States government already lists them as a transnational criminal organisation, and that triggers similar provisions to the provisions under Australia's criminal code if we listed them as a terrorist organisation. It criminalises association with them and support for them. And so it's the tool that we have in our toolkit, like the ones our allies are contemplating using, and I think we should stand with them, and actually we have an opportunity to lead them. I mean, it is in Australia's national interest that Ukraine prevail. We have to do everything we can in our power to ensure they do so. That's why we led the world outside NATO initially in providing military support to Ukraine. Under the new government, we actually slipped to second behind Japan, but nonetheless we still are a very strong supporter of Ukraine, and this would be one more thing we could do, an act of solidarity, but also a practical effect as well.
Earlier this year, a Senate Foreign Affairs, Defence and Trade Committee recommendation was made that the Iranian Revolutionary Guard should be designated as a terrorist organisation. The Attorney General's office said in February that it didn't have the ability to do that. Why is that? What's your understanding?
So the argument from the Attorney General's Department is that the IRGC is an entity of the Iranian state and it's not possible to list state actors. There's dispute about to the extent to which the IRGC is directed and operated by the state, but there's no dispute about the fact that it's engaged in horrific human rights abuses and is the world's #1 state sponsor of terror. In fact, it sponsors and directs many terrorist organisations which Australia already lists, like Hamas, Hezbollah, Palestinian Islamic Jihad. So they shouldn't be able to escape by means of a loophole from the consequences of their behaviour. And so again, we've said to the government, if a change to the law is necessary to list the IRGC, then we'll offer bipartisan support for them to do so.
I want to ask you about The Voice. Australia's Race Discrimination Commissioner says that making race the focus of the Voice debate will embolden racists and increase abuse and vilification towards Indigenous Australians. Do you share that concern?
I certainly think the tone in which we engage in this debate is going to be really important, because no matter what the result is, whenever the vote is held later this year, afterwards, as Australians, we have to coexist peacefully and pluralistically as neighbours and friends and co-workers and colleagues. And so we should conduct ourselves as much as possible in a good time. I think it's incumbent on both the Yes campaign and the No campaign to do that, and to try and make this argument about the things that it's of substance that's about. I am very concerned about the constitutional risk. I am concerned about the lack of detail. I am concerned about the fact that it's permanent, and I am worried that it won't make a practical difference for the lives of Indigenous Australians that it aims to.
And do you agree with Peter Dutton when he talks about The Voice re-racialising Australia? How would it do that?
Well, what the Yes campaign and the proponents of this case are trying to do is to treat Australians differently. Now, we could say that it's on the basis of their race, or if you prefer, we could say that it's based on their heritage or their ancestry or their ethnicity or their indigeneity. But either way, what we are doing is putting into our constitution something which treats people differently because of a characteristic over which they have no control. And I think that is offensive to liberal principles. I mean, we are all human beings and we're all Australian, and we should be all treated equally before the law and before the constitution as well.
But the coalition's position, though, is that you do want to recognise Indigenous Australians in the Constitution, and you do want a version of a voice to Parliament. Why is the proposed voice to Parliament the one that would re-racialise Australia? I'm just trying to understand what the difference is.
Well, because it puts it in our foundational document, in our constitution, and it involves a degree of constitutional risk, because it's not just symbolic recognition of a historical fact, which is what a preamble inserted into the constitution to recognise Indigenous Australians would do. It's something that grants a form of power to a voice to Parliament, which is yet ill-defined. We don't know how many people are going to serve on it. We don't know how they're going to be elected. We don't know the scope of its powers. And so that introduces real constitutional risk.
But do you support any kind of voice to Parliament?
I think there's a very strong case for local and regional voices to be legislated. That's a process that we initiated when we were in government, and I think it's very comfortably sits with liberal principles that local people are best enabled to make local decisions, that they should be consulted in that process. It's not clear to me how putting that in the constitution makes any difference to how it would work on the ground. In fact, it's just going to slow it down. We could have had local and regional voices up and running now, but after the change of government last year, the new Albanese Labor government put that process on hold.
Given the long history of race, though, in Australia's constitution, what would this do to re-racialise, to use that term that your leader has used?
Well, for a start, it would provide a constitutional hook for future High Court challenges to litigate the scope of the voice and the power of the voice. And it would mean that decision-making in this country would be influenced by a body either elected or appointed to represent some Australians based on their heritage or their ethnicity or their race or their background. And I think that is a risk, and I think that is a fundamental change to governance in this country. I think we should think very carefully before we proceed down that road.
If you are an Indigenous Australian, though, do you acknowledge that perhaps the way legislation is delivered, decisions are made, Merity, look, actually, that it is quite racialised, that the way our founding document was put together is quite racialised, and therefore a change like this might be necessary?
Yeah, I do absolutely understand that perspective, Hamish, because, of course, when this debate started, one of the things which it focused on was the removal of the race power that's in the Constitution. I mean, if we were sitting down again today to write our Constitution in a pluralistic liberal democracy, I don't think we would insert a power for the federal parliament to make laws according to people's race. And that's why, personally, I was very supportive of the initial moves about a decade ago to get rid of that race power. Now, the Yes campaign has moved away from that post the Uluru Statement of the Heart. That's not a priority for them, but I think that still should be on the table. I don't think it's a good idea in a 21st century liberal democracy that we should be able to make laws for people's race, because, of course, that does relate to Indigenous Australians, but it could also allow the federal parliament to make laws about any other Australian according to their race, and I don't think a parliament should have that power.
Do you think that the language of your own leader, though, may be contributing to the concerns raised by someone like the Race Discrimination Commissioner? I mean, he's made these comments in the wake of Peter Dutton's speech referring to the re-racialisation of Australia.
Yeah, look, I think that's unfair to single out Peter Dutton for criticism here, particularly given that some leaders of the Yes campaign, including on this very platform like Noel Pearson, have used it to viciously, personally attack people who have a different view. Even other people who are in supportive of a voice in the Constitution but have a different way about how we should go about that have been viciously attacked. I mean, Noel Pearson said that described Julian Lisa, my colleague, as a Judas. I mean, that's a shocking thing to say about a Jewish Australian. So I think Chintan and anyone else concerned about the tone of the debate should direct their criticism towards the people who are engaged in that personal vilification.
So when you read those comments from the Race Discrimination Commissioner, that's who you think of? You think of Noel Pearson?
I think we should think about anyone in this debate who's engaged in using any kind of slur, whether they're racial or religious or any other attempt to divide Australians.
James Paterson, thank you for your time this morning.
Thanks, Hamish.
That's the Shadow Minister for Home Affairs and Cyber Security. It's 12 minutes to 8.